Hey guys. So I know that the Scientific Skeptic has covered this subject mostly to everybody's satisfaction, apart from a few who can't really wrap their heads around it. So for those few who can't wrap their heads around it, I am going to skip through some of the information and show the receipts. Now, I understand that not everybody has a understanding of the legalese in the documents that these people have been referring to. So the Scientific Skeptic has a background in law, I think, international law, he says, and so I know that he has read these documents thoroughly. I'm not going to bore you with a thorough reading because there's a couple of hundred pages, but what I will do is I'll skip to the most pertinent parts and attempt to decipher them for you. Now, my background, I have in my degree I had to study commercial law and understand legalese and how to pull it apart and refer to case law, and I also have done a similar course in international law. So I will do my best to not just leave you with legalese and try to explain to you what that legalese actually means. So the first thing I'm going to do is I am going to turn to the documents that Chris McDonough relies on to assert some kind of innocence on his part, and this is the 2004 document. And just to show you that this is the 2004 document, we'll skip to the bottom of this page, which shows us when it was filed. So, dated the 17th of February 2004. So you can see that that's the document that they refer to. We will just skip back to the top for 1 second and show you that this was the Crowe plaintiffs versus the County of San Diego et al. I think the related actions were actually the county that Chris McDonough came from. Anyway, you can see that this is about the Stephanie Crowe murder in January 1998. And it does include the Escondido Police Department. Now, without reading through all 99 pages, I'm going to go to the judgment because this is pertinent. Defendant McDonough's motion summary for judgment of the claims asserted by plaintiffs Stephen Crowe, Cheryl Crowe, Judith Kennedy, Shannon Crowe, Margaret Hauser, Greg Hauser, Michael Lee Treadway and Tammy Treadway is granted. So this is what Chris McDonough relies on, that the summary judgment was granted in his favour. Summary judgment means without a trial. It just means that the district judge made a call without any trial. Defendant McDonough's motion for summary adjudication / judgment as to all claims by Michael Crowe, Aaron Hauser and Joshua Treadway is granted. The City of Oceanside's motion for summary judgment of the Monell claims asserted by all plaintiffs is granted. So the Monell claims are that the county can't be sued. We'll go into that shortly. The City of Escondido's motion for summary judgment of the claim was asserted by Michael Crowe is granted. So essentially this was a win-win for all of the police involved. They won. The damages against the counties were denied, and this is what Chris McDonough tells his audience is the end of the story. However, it is not the end of the story, because pursuant to this, in 2005, there was also this action that followed it up. Now, just to show you when this action was submitted to the court. This is the district court again, and this was in 2005, a year later. And so, what was this judgment? Might just zoom it out a little bit. The motion for summary judgment is granted with respect to the Crowe's Fourth Amendment claim arising out of the search of the residence. The motion for summary judgment is denied as to Cheryl and Stephen's Fourth Amendment claim arising out of their detention at the police station. The motion for summary judgment is granted as to the Crowe family's 14th Amendment substantive due process claims based upon the posting of photographs, as there is no evidence that the photographs were posted. The motion for summary judgment is also granted as to Cheryl and Stephen's 14th Amendment substantive due process claims based upon pointing of a gun at Stephen. I'm going to discuss these 14th Amendment substantive due process claims in more detail in a moment. But in this case it was granted. In addition, the motion for summary judgment is granted as state law claims for intentional and negligent infliction of emotional distress. Notice how this judge puts it. He calls it intentional and negligent infliction of emotional distress. And they granted the summary judgment. They granted the qualified immunity to the employees of the state, including Chris McDonough, this particular judge. So, finally, although one could certainly criticise the manner in which the investigation of Stephanie's murder was conducted, it must be remembered that the sine qua non of 1983 action is whether there has been a constitutional violation. It is not enough that the police may have been heavy-handed, mendacious and unprofessional. The acts of the police officers must be found to be in violation of the Constitution. While the court may not prove and condone the methods that the police employed, the court's personal predilections are necessarily irrelevant in a constitutional analysis. In part, this is true, the district court doesn't deal with constitutional issues. Now, here in Australia, if you are at the district court level and you raise a constitutional issue, it goes to the High Court, because the High Court deals with constitutional matters. It's a federal matter. The Constitution is a federal matter, and so the High Court deals with specifically constitutional matters. And I'm pretty sure that America's Supreme Court is equivalent to Australia's High Court. So in this particular case, the judge is correct that the district judge doesn't have jurisdiction to judge anything in relation to the constitutional analysis. Therefore, it goes to the higher courts. I will refer to this particularly comprehensive document written by a chap named Christian, who appears to be in the Chris McDonough camp. But the point of this particular resource is that he has put it all together into a bunch of links and documents and everything that we need to discuss what happened here. So in these resources, and you will also find these particular some of these court cases are actually listed on the Scientific Skeptics descriptions to those particular videos. However, this is sort of a more comprehensive list. If you want to refer to it, it's the crowemurdercase.wordpress.com. And so he just gives us this little summary here where he provides us with these court documents. In 1999, the three boys and their families filed civil rights lawsuits against the cities of Escondido and Oceanside and police officers and others involved in the case. A federal district court judge dismissed most of the lawsuit in 2004 and 2005, which we just referred to. The Treadway family dropped out and dismissed their case, but the Crowe and Hauser families appealed successfully to the Ninth Circuit Court of Appeals in 2010. A settlement was reached in 2011. The Crowe family received $7.25 million and the Hauser family received $4 million. Now I will just refer to this document here because this is the one that Chris M's supporters are not referring to, perhaps deliberately, perhaps ignorantly, I'm not sure. However, this is a far more comprehensive document because it is in the appeals court for the Ninth Circuit. It lists all of the plaintiffs: Michael Crowe, Stephen Crowe, Cheryl Crowe, Judith Kennedy, Sharon Crowe, a minor through guardian ad litem, Stephen Crowe, Zachary Treadway, Joshua Treadway, Michael Treadway, Tammy Treadway, Margaret Hauser, Christine Huff, Greg Hauser and Aaron Hauser. And it was against the County of San Diego, the City of Oceanside, Chris McDonough, Gary Hoover, Summer Stephan, Lawrence Blum, City of Escondido, National Institute for Truth Verification, and Rick Bass. The pertinent sections in this document, I guess the date is probably the first thing we want to see here. So here we see appeal from the United States District Court for the Southern District of California, argued and submitted on the 1st of June 2008 in Pasadena, California. The pertinent information in this document is around page 38, where we talk about the 14th Amendment. Substantive due process claims. Now I'm going to zoom all this in because people do complain that things aren't big enough on the screen for them to read. Okay. The Due Process Clause of the 14th Amendment protects against any government conduct that shocks the conscience. So you can refer to these case law studies because this is where they are drawn from. A Roshan versus California. You can look that particular case law up and you'll find that it went through the Supreme Court, and when things go through a Supreme Court and they make a new ruling that has never been made before, it becomes case law, and that's what we will refer to in future until a new ruling overrides that case law. So Michael and Aaron allege that defendants Blum, Risley, Sweeney, Clader, McDonough and Anderson violated their 14th Amendment's substantive due process rights by using interrogation techniques so coercive as to shock the conscience. It's important to note the difference in the language being used here, where the other judge didn't use any of this language, nor did he cite any of these case laws. The District Court granted summary judgment for defendants, concluding that the defendants' actions did not shock the conscience. And here they refer to the document that we were just reading to. So Crowe 1 and Crowe 2 were those two documents that I just referred to in 2004 and 2005. We have previously explained that police conduct need not include physical violence to violate substantive due process. Again, we see references to previous case law here, where it says holding that police interrogation plan to ignore suspects' requests for an attorney and relentlessly interrogate him violated the suspect's substantive due process rights. Again, it's another reference to case law. While brutality by police or prison guards is one paradigmatic example of a substantive due process violation that does not exhaust the possibilities. It also has long been established that the constitutionality of interrogation techniques is judged by a higher standard when police interrogate a minor. And again, we see case law being quoted here. In interrogation of a minor, the greatest care must be taken to assure that the admission was voluntary, in a sense not only was it not coerced or suggested, but also that it was not the product of ignorance of rights or of adolescent fantasy, fright or despair. The court goes on. The Crowes and the Houses presented the testimony from several expert and lay witnesses in support of their argument that the interrogations of Michael and Aaron violated the boys' substantive due rights. Dr. Richard Leo, an expert in coerced confessions, described Michael's interrogation as the most psychologically brutal interrogation and torture confession I have ever observed. Dr. Calvin Colarusso, Director of Child Psychiatry Residence Training Program at the University of California, San Diego, conducted a psychiatric evaluation of Michael and characterized his interrogation as the most extreme form of emotional child abuse that I've ever observed in my nearly 40 years of observing and working with children and adolescents. Robert Puglia, former Chief Deputy District Attorney for Sacramento County, testified in a sworn declaration that Michael's statements were the product of a coercive police scheme. And finally, a juror in Tuitt's criminal trial, who viewed the videotapes of the boys' interrogations, described the interrogations as brutal and inhumane and psychological torture. One need only read the transcripts of the boys' interrogations or watch the videotapes to understand how thoroughly the defendant's conduct in this case shocks the conscience. This is the judges, you see here where it says paragraph 10, this is the judges responding to what was presented just previously. Michael and Aaron, 14 and 15 years old respectively, were isolated and subject to hours and hours of interrogation during which they were cajoled, threatened, lied to, and relentlessly pressured by teams of police officers. Psychological torture is not an inapt description. Remember, this is Supreme Court judges saying this. In Cooper, we held that police violated an adult suspect's substantive due process rights when they ignored Cooper's repeated requests to speak with an attorney, deliberately infringed on his constitutional right to remain silent, and relentlessly interrogated him in an attempt to extract a confession. The interrogations of Michael and Aaron are no less shocking. Indeed, they are more so, given that the boys' interrogations were significantly longer than Cooper's. The boys were minors, and Michael was in shock over his sister's brutal murder. The interrogations violated Michael's and Aaron's 14th Amendment rights to substantive due process. Further, defendants are not entitled to qualified immunity because it was clearly established at the time of the boys' interrogations that the interrogation techniques defendants chose to use shocked the conscience. Defendants had the benefit of this court's holding in Cooper, this is previous case law, as well as Supreme Court case law, directing that the interrogation of a minor be conducted with the greatest care. Just as in Cooper, here qualified immunity is manifestly inapplicable. So these judges are overturning the district court judge's decision. However, in all fairness to the district court judge, he did recognise that he was not a constitutional professional. whereas the Supreme Court judges are. Now, probably the last thing to extract from this document is what were the final decisions that were made here. So we shall go to that. Before I read the conclusion, I will read the Monell claims that the Oceanside and Escondido police departments claimed about the municipal liability claims. In their complaint, plaintiffs as in the Oceanside City Police that were involved and the Escondido Police that were involved, assert causes of action against the City of Escondido and the City of Oceanside under Monell versus Department of Social Services, previous case law, because the District Court held that McDonough, the only Oceanside police officer named in the suit, was entitled to summary judgment with respect to all of plaintiffs' claims. The District Court determined that the City of Oceanside was also entitled to summary judgment on plaintiffs' Monell claims, which was in the first Crowe document. Similarly, the District Court granted summary judgment with respect to the Monell claims against the City of Escondido, which were predicated on alleged Fifth Amendment violations. So again, referring to previous case law where it says, neither Monell nor any other of our cases authorises the award of damages against a municipal corporation based on the actions of one of its officers, when in fact the jury has concluded that the officer inflicted no constitutional harm. Of course, we noted that those were summary judgments, they didn't have a jury or a trial, so these Supreme Court judges say, because we hold that the officers did inflict constitutional harm, we consider the Monell claim. Monell held that local governing bodies can be sued directly under the 1983 for monetary, declaratory or injunctive relief where the action that is alleged to be unconstitutional implements or executes a policy statement, ordinance, regulation, or decision officially adopted and promulgated by that body's officers. A municipality is not liable for all constitutional torts committed by its employees. However, a municipality cannot be held liable solely because it employs a tortfeasor. Or in other words, a municipality cannot be held liable under 1983 under a respondeat superior theory. The constitutional tort must have been committed pursuant to official municipal policy. Now, there's a lot of big words here, and I'm not even sure I pronounce all of them correctly because of the accent, but the judges do go on to sort of give some more explanation on that, so I don't think I need to really overcomplex what was said there. On appeals, plaintiffs allege their Monell claim on the basis of statements made by Escondido and Oceanside officials that McDonough, Clader and Risley complied with Escondido's and Oceanside's policies and procedures. However, Monell is clear that the constitutional tort must follow from official municipal policy. Plaintiffs do not allege that Escondido or Oceanside municipal policy permits or encourages the practice of coercing confessions. Therefore, the Monell claims fail. So they explain it pretty much in a nutshell there, that it wasn't part of policy. They're not claiming it was part of policy, and so the district court judge had actually erred in that particular instance. And so they overturn it. And so what we have here in the conclusion is we have half of the family's claims here are granted and or overturned from the previous decision. Half of them are not granted, and that seems fairly fair in my book, but they were not just trying to be fair, they were actually going by constitutional law. So we reversed the district court's grant for summary judgment as to number 1, Michael and Aaron's Fifth Amendment claims, number 2, Michael and Aaron's 14th Amendment substantive due process claims, number 3, all otherwise surviving claims against McDonough. So anything that McDonough was previously covered by qualified immunity, that's all been reversed. All otherwise surviving claims against Blum, again, everything against him reversed. The Crowe's deprivation of familial companionship claim based on Michael's detention, again, it's reversed. Number 6, the House's deprivation of familial companionship claim based on Aaron's detention. So that was 6 reversals of the district court's decisions. But we affirm, so this court is affirming the district court's grant of summary judgment as to number 1, Aaron's Fourth Amendment claim that police lacked probable cause to arrest him. Number 2, Michael's Fourth Amendment claim that police lacked probable cause to arrest him. Number 3, Michael's claim that police violated his Fourth Amendment rights by strip searching him. And number 4, Aaron's Fourth Amendment claim that warrants authorising the search of his home were not supported by sufficient probable cause. Number 5, the conspiracy claims against McDonough. Number 6, Michael and Aaron's defamation claims against Stephen, I think that's the prosecutor. 7, Aaron's defamation claim against Blum, and 8, all claims against the City of Escondido and Oceanside. So they're saying that the police departments are not responsible for what the detectives actually did. And they have not allowed the conspiracy claims against McDonough, but they have allowed all of the other claims against McDonough. Additionally, we affirm that the district court's denial of summary judgment as to number 1, Cheryl, Stephen and Shannon Crowe's claims that police violated his Fourth Amendment rights by strip searching them. 2, Cheryl and Stephen's Fourth Amendment claims that the warrant authorising police to draw blood samples was not supported by probable cause. 3, Cheryl and Stephen's Fourth Amendment claims of wrongful detention. And 4, the Crowe's deprivation of familial companionship claims based on the placement of Michael and Shannon in protective custody. We remand to the district court for further proceedings consistent with this opinion. So this is where the final claims in the district court resulted in the millions of dollars of damages. So it was a fairly fair judgment. They granted half and they affirmed the other half, pretty much according to law. So there was no playing favourite, and this is not a case of cherry picking judges. You actually get a panel of judges. I'll just see if I can find that for you, who all the judges were. Okay, so this particular document was a opinion by Judge Thomas in the circuit courts. It was before Stephen S. Trott, Sydney R. Thomas and Raymond C. Fisher. That's the circuit court judges that were part of the adjudication of this particular document, of this particular case. So if we're talking about cherry picking judges, then they had to cherry pick 3 circuit court judges, which I don't think that would be the case. I mean, where there was only one judge in the district court, yes, possibly they did cherry pick a judge, but I think it's a lot harder, and you want to be pulling things out of your backside if you really want to be pulling, the strings for 3 judges, because you're not always going to get 3 judges who are in total agreement with, some kind of fraud or whatever it is that they are claiming. So I believe that this was a fair judgment, and I believe it was fair to both parties. It was fair to the defendants and it was fair to the plaintiffs in this case. I believe the takeaway from this particular 2010 appeal is back up here on page 39. One very short sentence that the judges decided: psychological torture is not an inapt description. That's what the judges ruled. Regardless what Chris says in his own defence, that is what the judges ruled from watching the tapes and the interaction that went on. That is the overall takeaway from this document. All the claims that Chris McDonough was granted qualified immunity against the psychological torture of Michael Crowe and the other boys were all overturned. The judges agreed it was psychological torture. And they very clearly state throughout this document they didn't come to this decision because somebody else said it to them. They came to this decision because they watched the interrogation tapes. First part of the paragraph reads, "One need only read the transcripts of the boys' interrogations or watch the videotapes to understand how thoroughly the defendant's conduct in this case shocks the conscience." Now, some of us actually did watch parts of the interrogation tapes, and some of us read the transcripts, and it absolutely did shock our conscience. For other people to look at this and decide that it's not shocking at all, it could easily be said that they perhaps lack a conscience, because many judges and lawyers and lay people have looked at these and agreed that it does shock the conscience. The only people who don't agree that it doesn't shock their conscience are those who are still defending Chris McDonough, and of course Chris McDonough himself. Do they lack a conscience? I don't know. I'm not qualified to make such a call. With regard to the conspiracy claims against McDonough, let's have a closer look at that so we can be sure what conspiracy claims are being referred to here. Chapter 5, Conspiracy Claims. The District Court granted defendants a summary judgment motion as to all conspiracy claims against Defendant Blum and Fourth Amendment conspiracy claims against Defendant McDonough, on the grounds that neither Blum nor McDonough physically participated in the relevant arrests and searches, and there was insufficient evidence to establish that they were part of a conspiracy broad enough to encompass the relevant claims. We reverse the District Court's decision as to Blum and affirm as to McDonough. The Fourth Amendment protects people from unreasonable searches and seizures by the government. So it was only affirmed as far as McDonough's involvement in arrest and seizures. That's it. That's all it is. You can read the rest of the paragraphs here, but I'll spare you. That's all it affirms. If you go back to what the Supreme Court reversed, it says all otherwise surviving claims against McDonough. That is, all of them except for the conspiracy regarding the Fourth Amendment claims, because there was no conspiracy there. McDonough had nothing to do with the arrests. However, all otherwise surviving claims against McDonough were reversed. Now, they might say that this was all motivated by money. However, I found numerous articles and places where the Crowe family and others have spoken with the press, and I will quote directly from Michael Crowe himself, now an adult. "Justice for me would be admissions and apologies." This may sound very familiar because this is also what Jamie Wilson, AK and Nomadic Trek said, where Chris McDonough would have us all believe that all of these people were just trying to get money off him, just trying to take from him. Chris McDonough chose to be sued by the families involved with the Crowe case. Cold hard science proved him wrong. DNA testing. He could have admitted he was wrong and apologised, but he doesn't possess even enough humility to save his own skin. Instead, he co-authored a book doubling down on his assertions and gave these families a reason to sue. Fair enough, they did not win on their defamation case. However, they won on everything else. They won on legal standing. They won on constitutional grounds. And none of it would have happened had Chris McDonough possessed enough humility to apologise and admit he was wrong. That's really the cold, hard facts here. Science proved him wrong, not his idea of the Reid technique, which we will go into next. Science, cold, hard science proved him wrong. He only needed to apologise. I'd like to read to you what Donald McInnes, who was Aaron House's defence attorney, has to say about the techniques used on the boys. He's lobbied the government for better protections for children as far as Miranda rights go. He says, in a series of long, ruthless interrogations using the Reid technique of psychological interrogation, the police were able to get Michael to say he knew he killed her but couldn't remember how. This confession was never supported by any physical evidence. What followed next is a series of nightmarish events leading to the arrest of the two other boys who were interrogated, arrested and prosecuted along with Michael for the murder of Stephanie. Think this couldn't happen to your child? You are wrong. In the last several decades, thanks to DNA testing, hundreds of teenagers and adults have been exonerated and their confessions found to have been coerced by police through psychological manipulation. The author explains the Reid technique of interrogation, its 9 steps of psychological deception, and illustrates how this alternate form of the third degree produces false confessions. In the book, we have Appendix 1. In this appendix, Donald McInnes outlines the Reid technique, and we will run through it very quickly. Step 1, direct confrontation of the suspect. I won't read all of this so we can save some time. Theme development, which is presenting a moral justification or theme for the offence. Step 3, handling denials. You must reject all denials, stop them from denying. Step 4, overcoming objection. Again, stop objections. Step 5, retention of participation. That is preventing any kind of withdrawal and keeping it going. Step 6, handling the suspect's passiveness. Part of withdrawal, but not allowing the suspect to be passive. Step 7, the presentation of alternatives. Step 8, suspect orally confesses, and step 9, the written confession. I will read the analysis. A key element of the Reid technique is the interrogator's ability to detect when a suspect is lying. Thus, the emphasis is on getting to know the suspect and his or her background through a period of non-confrontational interviews, and the necessity to observe how the suspect reacts through the period of interrogation. However, various studies challenge the ability of a person, even a trained investigator, to discern truth from lying. This is particularly important when dealing with the young, poorly educated, those under great stress, or suspects who have been traumatized. The mentally ill can be especially difficult to read due to inability to understand the motivation of their responses. There are, however, other methods of interrogation, one of which is employed over here in this side of the world, particularly here in Australia and England. There are other types of psychological methods of interrogation that are not as confrontational as the Reid technique and do not use deception. The kinesic interview method has some similarities to the Reid technique in that it requires the interviewer to analyse the suspect's behaviour in order to determine if he or she is lying. Kinesics is communication through human body motion and was first used by anthropologists to study human posture, gestures and movements. In 1970, Professor Ray L. Birdswhistle published a book titled Kinesics in Context. From this publication and subsequent research, the kinesic interview method of analysing non-verbal human behaviour was devised. During the orientation and narration period, the interrogator studies non-verbal communication traits of the suspect. Walters refers to this phase as the analysis phase. The interrogator uses the information gathered during this phase in order to tailor the confrontational cross-examination stage. Walters describes 30-some human traits as guides to evaluating a suspect's responses. These body language movements help the police determine when the suspect is lying. According to the kinesic method, denials by the suspect should be confronted with only real or circumstantial evidence, not lies. The peace method of interrogation is taught in England throughout the College of Policing, also here in Australia. Peace stands for preparation and planning, engage and explain, account, closure and evaluate. Under the peace method of interrogation, the suspect is presumed innocent and as a consequence is allowed to tell his or her story without interruption or accusations. The investigator may ask the suspect questions about the narration in order to clarify what is being told. The investigator then confronts the suspect with inconsistencies or contradictions between the suspect's version of events and the evidence. The investigator may even point out the implausibility of or inconsistencies in the suspect's own statements or story. However, in the peace method, the officer is prohibited from deceiving the suspect. It's probably high time that the peace method be employed in America and the Reid method be ditched. We have reduced our number of overturned convictions in Australia simply by employing this new peace method. Further, Donald McGuinness has championed a bill to put before the Senate, adjusting the way children's Miranda rights are read to them so that they fully understand their rights. Standard Miranda rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. He has suggested making this far more understandable to children because they do have more rights than just an attorney. He suggests you have the right to remain silent. This means you do not have to say anything or answer my questions or any other officer's questions. Anything you say may be used against you. This means what you say can be used against you in juvenile court or, if you are charged as an adult, in adult court. In other words, what you say can get you in trouble. Before and during all questioning, you may have your parent or guardian present. You may talk privately with your parent or guardian. So before you say anything, you may talk with your parent or guardian. You or your parent or guardian may talk to an attorney free of charge before talking to us. You or your parent or guardian may stop the interview at any time. You or your parent or guardian may at any time have a free attorney with you during questioning. Do you want to talk to your parent or guardian? Do you want to have a lawyer present? Do you want to talk to us? McInnes goes on to say, Miranda rights are effective only if those rights are fully understood. To advance the understanding of those rights, a Children's Bill of Rights is proposed. You can read that document yourself to see what he has proposed for a Children's Bill of Rights. So all Chris had was these coerced confessions ruled as psychological torture by the Ninth Circuit Court, and he and his colleagues' opinions regarding the boys' behaviour and their apparent interest in medieval art history. Let me show you the overwhelming evidence that they completely ignored. This is considered exculpatory evidence by the court, the withholding of which is called a Brady violation. And you can find this in Brady versus Maryland, where it was held that withholding evidence is a violation of due process. Now, I will refer back to this wonderfully well-documented publication on WordPress to summarise the overwhelming evidence presented in the actual murderer's trial. And we can see here that there is quite some information on Tuart, the actual murderer, and I am going to refer to sightings of Tuart before the murder. In addition to the sightings of Richard Tuart on the night of the murder and the days and weeks after the murder, Tuart had been searching for Tracy prior to then. Cecilia J. saw Tuart on her apartment doorstep a week or two before Stephanie's murder. He knocked on her front door during the day. Before Cecilia responded, Tuart turned the door handle and tried to open the door. Cecilia shut the door, locked it with a deadbolt, and went to a balcony and asked Tuart why he was there. Tuart asked if Tracy was home. Cecilia told Tuart no one named Tracy lived with her. Tuart left after Cecilia repeated herself a couple of times and ordered him off her property. This gets quite extensive. These are not just isolated events, but there's a reason I'm going through it, and I will come to that in a moment. Tracy Nelson, the object of Tuart's seeming obsession, said that Tuart showed up at her grandfather's house in January 1998 asking for her. Tuart left but returned the next day. Her grandfather told Tuart he would call the police if he came back. Tuart was also contacted by police several times in the days immediately preceding Stephanie's murder, including the day of the murder. On January 3rd, 1998, San Diego County Sheriff's Deputy Augustine conducted a field interview of Tuart. He contacted Chewett in response to a radio call of a transient male walking through backyards and looking in windows. On January 16th, Escondido police officer Sanders conducted a field interview of Chewett. He observed Chewett behind Weber's bread stall. On January 17th, Escondido police officer Bowdy Barrett conducted a field interview of Chewett. He contacted Chewett in response to a complaint of someone panhandling in front of Sabu Foods. On January 18th, Escondido police officer Rodriguez responded to a complaint of a suspicious person matching Chewett's description walking through the apartment complex looking for someone. Rodriguez was unable to locate the subject and cleared the call as gone on arrival. Still on January 18th, Escondido police officer Keith Sudak conducted a field interview of Chewett. He contacted Chewett in response to a complaint of someone trying to open car doors. On January 19th, Escondido police officer Jacob conducted a field interview of Chewett. He contacted Chewett because of a call of someone following kids in an apartment complex. On January 20th at 7:30 a.m, Escondido police officer Steve Sanders conducted another field interview of Chewett. He contacted Chewett wandering around several malls and stores. Sightings in Chewett on the night of the murder. On the night of Stephanie Crowe's murder, there were a series of sightings of Richard Chewett in the general vicinity of the Crowe house. These sightings, except one, are indicated on this aerial photo. Let's have a look at the photo. So he was all over the place. Crowe's residence open door. That is very interesting. We'll come back to that. The sightings of Chewett on the night of January 20, 1998 are as follows. At about 6 p.m, Rebecca McCaslin and her son were driving home when they saw an agitated Chewett standing on a street corner at Date Street and East Grand Avenue. He was walking around talking to himself and pointing in the air. Danette Mogilensky and her boyfriend, Frank Romanelli, were at home when Chewett knocked on their door about 7 p.m. Mogilensky said, "It's open, come in." Chewett opened the door but did not step inside. He asked for Tracy. When Mogilensky said she did not know anyone named Tracy, Chewett shut the door. A few seconds later, Chewett reopened the door without knocking and asked, "Are you sure you don't know where Tracy is? Richard is looking for her." Chewett stared into the house as Mogilensky closed and locked the door. At about 7:15 p.m, Sharon Thomas saw a man she could not positively identify as Chewett near a church at Lake Wolford Road and Valley Centre Road. The man walked through the church parking lot saying loudly, "You better never do that again. I'm going to kill you, you fucking bitch." He appeared to be under the influence. Between 7 and 7:40 p.m, Sheldon Homer saw Chewett walk by his window and that Chewett pressed his face against the window and looked inside. Sheldon grabbed an axe for protection and ran outside and asked Chewett what he wanted. Chewett said he was searching for a girl named Tracy and that Mogilensky had suggested he check for her at the Homer residence. Sheldon told Chewett he was lying and ordered him to leave. Chewett left. Sheldon's son Shannon lived nearby with his girlfriend. Sheldon went to Shannon's unit and asked him to call the police. Shannon and his girlfriend decided to follow Chewett in their car. Chewett walked down Valley Centre Road, went to the parking lot of the Lutheran church, walked over to the Lake Wolford Road and stood in the road with his hands in the air, walking in circles. Chewett then headed back up Valley Centre Road and turned right. Shannon and his girlfriend returned home and Shannon called the police. Escondido police officer Barry Osowski responded to the 911 call and arrived at the Lutheran church at 8:15 p.m. Osowski did not see Chewett and closed out the call. At approximately 9:20 p.m, Chewett approached the West Green property, which was between 1/4 and 1/2 mile away from the Crowe house, banged on the door of a trailer and yelled, "This is Richard, I want to see your daughter Tracy." Patrick Green, who lived in the trailer with his wife and daughters, told Chewett no one named Tracy lived there and ordered him to leave. However, Chewett, who appeared intoxicated, insisted Tracy was there and kept banging on the door. Green grabbed his pellet gun and he and his wife went outside to warn his father-in-law, Gary West, who lived in the main residence with his wife. Chewett banged on the West's door and said, "I want to see the girl." West ordered Chewett to leave and said he was calling the police. Chewett walked backwards down the driveway, staring at the West and the Greens. Then he turned around and headed up the road leading to the Crowe's house. West went inside and called the police. Responding to West's 911 call, Escondido police officer Scott Walters drove around the area looking for Chewett but did not see anyone. Walters circled the West driveway in his patrol car and then drove to the Crowe house. Walters noticed the door leading from the laundry room to the interior of the house was open. This is very key because all the other claims are that there was no evidence anybody being able to go in and out of the house unseen. As Walters circled the Crowe's driveway, his patrol car activated the sensor light above the exterior laundry room door, and the door closed from the inside. Because he did not see Chewett, Walters considered it a no-contact call and left. He listed the suspect as gone on arrival. Cynthia Ames and Elizabeth Miller drove to Miller's home at about 11 to 11:30 p.m. They saw a man that looked like Chewett standing at the foot of the driveway that leads to the Crowe's house, with his hands in his pockets looking up at the house. And now we will go to sightings of Chewett after the murder. Sightings of Richard Chewett continued in the days and weeks after Stephanie Crowe's murder. The morning of January 21, Mark D. drove to work through Escondido shortly before 5 a.m. He saw Chewett walking fast, almost spastically. His shirt looked sweaty, his hair looked stringy. Hope T., who had known Chewett for about 15 years, saw him come into the Von's grocery store at 7 a.m. on January 21st. Chewett did not look sweaty. He moved slowly and minded his own business. At 8:15 on January 21st, Chewett approached Nora Lee D. as she was returning to her apartment. Nora Lee entered her apartment, shut the door and turned the deadbolt. Chewett immediately knocked on the door and Nora Lee told him to leave. Chewett responded, "If you'll let me come in, we can talk more." He spoke in a quiet monotone and talked about a friend living in Nora Lee's apartment or in the area. He did not seem angry or hostile. Nora Lee called the police. Subsequently, Chewett knocked on the door to apartment number 26 in the same apartment complex. Sandra F., who lived in the complex, told Chewett that apartment number 26 was vacant. Chewett said he was looking for Tracy. Chewett followed Sandra and tried to enter her apartment with her. Sandra's husband told Chewett to leave and he complied. While still in the same apartment complex, Chewett locked himself in the complex's laundry room, thereby inspiring another call to the police. Officer Huston responded and removed Chewett from the laundry room without incident. Officer Huston searched Chewett and did not find any weapons or contraband on him. Still on January 21st, just before 7 p.m, detectives investigating Stephanie Crowe's murder were following up on Chewett and learned that Chewett was panhandling at a laundromat at Midway and Valley Parkway. Detectives saw Chewett standing at the west end of the Lucky supermarket, where he appeared to be loitering and waiting to panhandle from customers. Detective Sweeney told Chewett that he was investigating a serious crime that occurred in the area of East Escondido and that he would like to take Chewett to the Escondido police station to process him for possible evidence of crime. Chewett voluntarily agreed to go to the police station, where he was photographed, had his clothes impounded, and briefly interviewed. On January 22nd, Chewett went to another apartment complex in Escondido, where he banged on the door of a vacant apartment, which had an eviction sign in a window. The maintenance man asked Chewett to leave. Chewett said he was looking for Tracy. A police officer contacted Chewett behind the complex. Chewett did not have any weapon and seemed disoriented. On January 25th, Chewett was reported hanging around a hotel parking lot and looking into car windows. Upon being contacted by a police officer, Chewett stated that he was waiting for a friend to let him inside the hotel. When asked if he knew anyone staying at the hotel, Chewett replied that he thought the family of that kid who got killed was there. On January 26, Frank S. was at home watching television just before midnight when a motion light detector activated outside his house. He looked outside and saw Chewett standing at his doorstep. Chewett was turning or shaking the door handle to the front security door. When he found it locked, he stayed on the porch. Frank called police, who briefly detained Chewett. Chewett told the police officer that he was looking for an old friend. While the police officer spoke to Chewett, an unknown citizen approached the officer. The citizen said Chewett had been knocking at his front door for several minutes. When he opened the door, Chewett began mumbling something about looking for Tracy. On January 27th, Joyce F. was home when Chewett opened the front screen door and turned the doorknob to her home. Joyce asked who was there. Chewett replied he was looking for someone named Richard, or that he was Richard. Joyce told Chewett to leave, but he kept trying to open the door. Joyce called police. On February 12th, Chewett was on a bus seated near two girls aged 12 and 13 who were riding on the bus with the 12-year-old's mother. Chewett was constantly looking back at them out of the corner of his eye. He followed them when they transferred buses and continued to stare at them on the next bus ride, causing the girls to put their jackets over their heads. At one point, he asked the mother if the girls were her daughters, and she replied that they were. Chewett got off at the same stop as the girls' mother. The girls walked quickly to their apartment while the mother went to the supermarket to get a drink. The girls went inside the apartment, then came out of the apartment to look for the mother. The girls met up with a friend and started walking with her. Chewett came up to the three of them in the apartment complex. The friend told Chewett to leave the girls alone, and he left. As the girls walked away, Chewett said to them, "Come here, I want to have sex with you. And please, Tracy, come here." Chewett was arrested and is cited for annoying, molesting children. On February 17th, before 7 a.m, Chewett went to the residence of Patsy W., pounded on the door and kept repeating, "Tracy, Tracy." Chewett tried unsuccessfully to open the door. Patsy called police. Police arrived and talked to Chewett. On February 21st, Chewett peered into the window of Meredith B.'s residence. When asked what he wanted, Chewett said he was looking for someone. Meredith said she was the only person there, and Chewett backed off apologetically and left. On February 24, Chewett was knocking at doors of various apartments in a complex. The manager walked through the complex and found Chewett knocking at one of the doors. He asked Chewett to leave the property. He watched as Chewett walked away from the apartment and went to another door. This continued for 3 more doors. And at the 4th door, after being told to leave the complex again, the manager asked a resident to assist him in taking Chewett into custody. They placed Chewett in handcuffs and told him he was being placed under citizen's arrest for trespassing. Chewett followed the manager to the office and a phone call was made to the police. On February 25th, at around 5 a.m, Roxanne N heard a faint knock at her door. She realised someone was turning the handle. Chewett pressed his face against a window and looked inside. Roxanne hit the front door to scare him and called police. Chewett left. On March 11th, Chewett was observed in a trailer park, knocking on trailer doors and trying to open them with his hands when no one answered. At one trailer, he was able to open the door and enter. 5 minutes later, he exited the trailer. A second witness observed Chewett a few minutes later trying to break into another empty trailer by prying open a window with a black plastic fish. Chewett was immediately arrested after this witness confronted Chewett and told him to sit down while the witness called the police. Chewett showed the officer where he had dropped the plastic fish. Chewett was arrested for the felony of attempted burglary. He was later sentenced to 3 years in a state prison. On March 13, while Chewett was in the mental health ward of the Vista jail, he paced back and forth, raised his arms up and yelled, "Tracy, you whore, I'm going to kill you." Now I'm going to refer to 4 historical incidents concerning Chewett, some of which the jury never heard. On April 7th, 1990, a deputy sheriff contacted Chewett and searched his knapsack. It contained several knives, including folding knives. On August 4th, 1993, an Oceanside police officer contacted Chewett in Buccaneer Park and discovered that he possessed a steak knife. What the jury never heard was that Chewett had used the steak knife to stab someone. According to witnesses and the victim himself, Chewett walked up to the victim, who was sitting and talking with friends, in a casual manner. Without warning, Chewett stabbed the victim several times with a steak knife. The victim's friends grabbed Chewett and pulled him off the victim. They detained Chewett until police arrived. The victim sustained deep lacerations to his head, back, and left hand and was transported to the hospital. The victim told police he had never seen Chewett before and had no idea why Chewett attacked him. According to the police officer, Chewett appeared to be disoriented and he didn't recall the incident. In a 2000 interview with homicide detective Victoria Kaloka, who was then investigating the murder of Stephanie Crowe, Chewett said that he remembered he had been strong-armed out of something that belonged to him, a bike, but said he would rather not talk about the incident. Chewett was charged with assault with a deadly weapon. However, the victim failed to appear in court and the charges were dismissed. On January 6, 1996, Carlsbad police officer Hart saw Chewett pushing a bicycle on Carlsbad Boulevard. As Hart approached Chewett, he began to walk away from him. Chewett then removed a knife from his waistband and threw it in some bushes that lined a sidewalk. Hart confiscated the knife, a Big Chief brand with a 6-inch blade. On October 29, 2001, David Douglas contacted Chewett in Sacramento. Chewett had a 7-inch folding knife with a 3-inch serrated single-edged blade in his right front pants pocket. Now, I'm going to go through some of these incidents because the police notes do show us what he was wearing. So we will go back to the 16th before. Let me just check that I've got the right one. Where's the date on that? Okay, this is the 19th of the 1st. So we have a look at what was he wearing. He was wearing the white t-shirt and red sweatshirt on the 19th when he was stopped by police. We see here on the 16th of the 1st, he was still wearing the red shirt 3 days earlier. We also see here on the 20th of the 1st, he is still wearing the red shirt. Being a transient, we do not find this surprising. However, this disproves that he picked the shirt up out of a bin after Stephanie was murdered. He was wearing it as many as 4 days earlier, or for the entire 4 days. Now we will get to the DNA evidence. Now I will skip over, this is a CBS News article, and in this we talk about Attridge. Okay, Mary Ellen Attridge. Josh's confession gave the most details of Stephanie's murder, but his public defender, Mary Ellen Attridge, was relentless in her belief that police set the boys up. "They're not confessions," says Attridge. "They're false. They are lies, and they were manufactured out of whole and coercive cloth by the police department." Attridge planned to dispute the boys' so-called confessions, revisit the questions about Tuitt, and paint him as a likely killer. She wondered about the clothing that was taken from Tuitt on the morning Stephanie's body was discovered. It was clothing police said contained. She discovered that only Tuitt's white shirt had been tested for DNA evidence, not his red sweatshirt, which had stains on it. "I didn't know what it was," she said. "I suspected that there had to be some sort of DNA on there somewhere." Attridge demanded that prosecutors send all of Tuitt's clothing for DNA testing. The DNA lab found 3 spots of Stephanie's blood on Tuitt's red sweatshirt. "I thought this was it," says Attridge. "Richard Tuitt killed Stephanie Crowe. Absolutely, positively, no doubt about it." Now, I want to point out some obvious sloppiness in this investigation. I am by no means a detective or prosecutor, but it seems very obvious to me that Tuitt wore the red sweatshirt over the top of his white shirt. So why did they only test the undershirt? Was it because Chris McDonough and his crew had already marked Michael and his friends for the crime? The significance of the DNA results from the clothing stands in stark contrast to the DNA results obtained by the prosecution from the knife found under one of the boys' beds. Let's refer back to this handy little WordPress document which lists the findings of the DNA tests performed on the knife. Examination of the knife. Detective George Durgan took apart the knife and testing it using fluorescein, which is a presumptive blood test. The knife reacted positively in certain areas consistent with blood. Durgan testified before the grand jury. We had tested the knife blade itself, looking for any possible blood using a common presumptive test, which is a lot less sensitive than fluorescein, and that was negative. Then we took the knife apart, which meant that we took the plastic hand grips off, and we also had the knife itself, and we sprayed it with fluorescein. The grip on the right side, as if the blade was down, did fluoresce in an area approximately 1 inch by 1 inch. Later testing was negative for blood. Swabs taken of the knife were sent to the Serological Research Institute. Seri reports Reid. Item 36, swab from knife handle. This item consisted of a swab with yellow-brown staining. The staining was chemically tested for the presumptive presence of blood with negative results. The staining was excised and extracted for DNA content. No DNA was recovered. Item 37. This item consisted of a swab with dark grey staining. The staining was chemically tested for the presumptive presence of blood with negative results. The staining was excised and extracted for any DNA content. No DNA was recovered. Now, we have seen this in countless other appeals where preliminary luminol tests have reacted to other biological matter aside of blood, because that's the nature of luminol and these substances. They're designed to react to biological matter, not just blood, and that is precisely why it's only a preliminary test that is later confirmed or denied by DNA testing. What we've seen here in the Crowe case is that cold hard science held Chris McDonough's junk science to the flame and burned it to the ground, at a mere cost of millions to the taxpayer. Anyway, that should clear up all the lies and deceit surrounding Chris McDonough's culpability regarding the psychological torture of those boys. I stand firmly with the scientific skeptic. Real science reigns supreme, right next to the opinions of the 3 Ninth Circuit Court judges who ruled what was done to those boys as outright psychological torture, and given their ages at the time, amounts to nothing short of child abuse. Rather than admit he was wrong and apologise, Chris would prefer to burn it all to the ground. This, as Scientific Skeptic has pointed out, appears to be his pattern of behaviour. I have one final thought to share with you. Why isn't Chris M peddling his own story? Why is he getting all of you to peddle his story? Could it be because the $7.4 million richer Crowe family will undoubtedly sue his ass the very second he opens his own mouth? He's getting you to tell the story because it'll be you who gets sued, not him.
Oh, Magoo, you've done it again.